Good morning, everybody, and thank you for joining us today for the RTA webinar. And our topic today is the overview of the 1 May 2025 rental law changes. Before we start, I'd like to acknowledge the traditional owners on the land on which we meet today and also where you are joining us as well, and pay our respects to elders past, present, and emerging. My name is Lynn Smith and I'm joined today with my colleague Mark Fiddler. Mark and I are in the education team at the RTA. We both have been here for around 20 years each and bring a wealth of knowledge and experience with Queensland tenancy laws. Thanks for partnering with me today, Mark.
Thanks very much for having me, Lynn, and thanks very much to everyone who's joined us so far.
Now, just will also acknowledge that we do have an audience that we have managers, owners, tenants, community organisations and other departments joining us today. So welcome everybody, and again, thank you for joining us. So today we'll be looking at the journey so far with the rental law reforms and then dive into the topics that you see on your screen, which are the changes that's occurring from 1 May 2025. So during the session, Mark and I will also look at questions that we've been receiving from events that we've been delivering across Queensland, and we're going to answer those questions for you today. Now, if you do have a question as we go through each topic, please pop it into the chat and we'll do a Q&A at the end of the session. Remember, as always, the RTA is here to help you navigate these changes and also to help the sector understand their rights and obligations. So for those not familiar with the RTA, we are an independent statutory authority and our services include our contact centre, where on average we receive around 1,400 calls a day. We also offer a free dispute resolution service where we resolve 3 in 4 tenancy and bond disputes. And as Queensland's rental regulator for more than 30 years, we also undertake proactive and reactive monitoring and compliance and enforcement activities. We hold and manage just over 600,000 rental bonds, and we also work with our key stakeholder groups across Queensland, and also to the RTA's core function is to administer Queensland's tenancy laws. Keep in mind, we don't write the legislation. Our function is just to administer the laws, and also our role to help parties in a tenancy understand their rights and obligations. Now, if we look at the rental journey so far, this started back in 2021 with the Housing Legislation Amendment Act 2021. So the key changes were implemented in a staged approach in 22, 23 and 24. So last year, the Residential Tenancies and Rooming Accommodation and Other Legislation Amendment Act 2024, yes, that was a mouthful, was passed in Parliament. And again, the key changes were implemented through a staged approach. So we're going to look now at the changes coming for 1 May. So if you want to know more information about the previous changes, or if you've got questions about the previous changes, please jump on our website and search for the rental law reforms. But keep in mind today, our questions are focused purely on the changes that we have on 1 May. So first, let's talk about personal information. So we're in today's world, protecting privacy and personal documentation is important to everyone. So there will be new limits applying to personal information that a property manager or an owner can request from a tenant, and also to a time frame outlining the securely storing and also the destroying of personal information to be done by a manager or an owner. So now this does apply to both physical and digital records that may be collected and stored during the application process or throughout the management of that tenancy. Now we are asked, well, what is personal information? So the Act refers to it as information or an opinion about a specific person or someone who can be reasonably identified, whether it's true or not. And it also covers photographs or images of someone's personal possessions or standard of living. So what we know here is that this is also looking to capture any photos that may be taken during like a routine inspection. Now, the time frame is split into two areas. So let's start with prospective tenant information, and this is from a tenant or a resident. So if we look at this column on your left-hand side of the screen, this is going to include their application and personal documentation, and it must be securely stored, accessed only by the relevant person assessing suitability, and destroyed within 3 months if the applicant does not become the tenant. Now, a prospective tenant may choose to agree in writing for a longer period. So we know that for our community housing providers, it may be that you're looking to hold that application for a longer period of time, and that's okay, providing the prospective tenant agrees to do so. Now, if we look on the other side here of the column, if you look at for a tenant or resident in the actual tenancy, it must be securely destroyed within 7 years after the end of the tenancy or rooming agreement. So with a prospective tenant, it's 3 months. With the actual tenancy itself, within 7 years at the end of that tenancy. So keep in mind too, there are still requirements under the Act for storing the normal tenancy paperwork, such as your tenancy agreement, entry condition reports, and rent payment records. This still remains, and nothing's changed in that space, and it must be kept for at least 1 year following the end of the tenancy. So Mark, I know we are getting a lot of questions coming in. So I just want to flag too, we do have a lot of people on today, but we are going to try and see if we can get to all those questions. But Mark, I'm going to invite you in. Let's have a look at some of the questions that we know are quite popular, what we've been getting asked, and you may find that this might actually also help some of the questions that we've got coming in as well. So what information can be collected by a manager or owner during the tenancy?
Yeah, thanks, Lynn. So look, during the tenancy, information can be collected if it's related to the management of the premises. So this can include photographs taken during the property inspection, as they're considered part of the information necessary for managing the premises.
Okay, our next question, what happens if a tenant or resident still owes money after 7 years? Can an owner continue to hold on to that personal information of the tenant?
The Act doesn't provide an exception in this situation, so all personal information related to the tenancy must be securely destroyed within 7 years after the end of the residential tenancy or rooming accommodation agreement to which the information relates. Customers might need to consult legal representative regarding the statute of limitations in Queensland relating to personal debt.
Okay, so it's kind of like, yeah, probably pushing them a bit more to get that legal advice.
Yeah, absolutely.
Um, what happens if the information is stored offshore and not stored locally? And I know this actually is going to answer about a few questions that we've actually just come through now. So it's a
Yeah, so
popular question.
the requirements specifically address the collection, storage, and destruction of personal information within the context of your residential tenancy or the management of that tenancy. The Act doesn't make any references to where that information's stored. So the requirement is that it's stored securely and only accessed by relevant persons.
Okay, so again, like doesn't matter whether it's electronic or paper-based, if you're in storage, it still has to meet those requirements.
That's exactly right. Yeah.
Now, if photos have already been sent to an owner from a routine inspection, do they have to destroy that information within 7 years?
Yeah, in a word, yes, they do. So the requirements, whether you're the property manager or the owner, the requirement is that that information is securely destroyed within 7 years after the end of the tenancy. And I guess what this leads to is a little bit around where is your information stored? And so a sent email, if it's sitting in your sent email folder, it would need to be removed and destroyed within that 7 years. So you will need to be conscious of where you've got information and how it's being stored, and ensure that your obligations around that 7 years are met.
Excellent. Thanks, Mark. Okay, so our next topic we're going to talk about is around the entry notice period and the frequency of entry from 1 May. So the legislation outlines the rules of entry and the timeframes, so nothing's changed there except that the entry notice periods that are currently 24 hours will be increased to be 48 hours. So this will be for situations like showing a prospective buyer or a tenant through a rental property, repairs and maintenance, entries for valuations. So there is a list in the Act that are 24 hours, so it's going to be increased to 48 hours. There is an exemption for anyone doing rooming accommodation, and that's for cleaning. That will still remain at the 24 hours. So do please keep in mind there's mutual agreement between a tenant and the manager or owner or a secondary agent that is still available. So if a property manager or an owner or a tradesperson is looking to gain entry under the 48 hours, then that can occur if the tenant agrees. So the other change that's coming through is once the notice to end the tenancy has been issued. Now, this could be a property manager or an owner issuing a notice to leave, or it could be a resident or a tenant issuing a notice of intention to leave. Then the frequency of entry will be limited to no more than twice in a 7-day period. Now, the purpose behind this was around quiet enjoyment when a tenant is looking to end the tenancy and pack up their possessions and look to move out. So with regards to the frequency of entry, if there is a secondary agent, so as an example, maybe a selling agent or another person looking to gain entry that may be different to a managing agent, they will need to be aware of any notices that may have been issued during that tenancy to end the tenancy. So what does this look like? And I'm just going to pull up a slide to show you an example. Just to clarify that the 7-day block of time starts when the notice has been issued to end the tenancy. So in the example I've got on the slides here, in this case, say it was done on the Tuesday. The example shows there's 3 types of entry that wants to occur. And again, the correct notice has been issued for these examples. So yes, the routine repairs is okay for Thursday. Then we have on Saturday to show prospective tenants through. Yes, that's okay too. But come Monday, another lot to show prospective tenants through, well, that would not be okay because it's a third entry within a 7-day period. So on that one, the only way that entry could actually happen if there is mutual agreement. Now, with this frequency time frame of the twice in a 7-day period, the entry provisions for emergency repairs, compliance for fire and electrical safety are exempt. So again, they can happen, but mutual agreement can also occur if it's agreed on in this time frame. So Mark, come on back, and has the entry time frame for general inspections changed?
No, it's still 7 days and not less than 3 months since the previous entry for the same reason. So that hasn't changed at all. In a rooming situation, those timeframes remain at 48 hours and 1 month between the inspection.
Excellent. So nothing's changed for rooming.
No.
If a notice to leave due to end of a fixed term tenancy is issued at the same time of signing the agreement at the start, am I captured in the limit of frequencies throughout the whole agreement, or is it just towards the end of that term?
Yeah, good question. And we see this, look, we're aware of this practice still occurring, even though we consider it to be against the spirit of the legislation. And the answer is yes, you are captured for the full term of that tenancy agreement because that notice to leave is in effect effectively in place for the full term of the agreement. So you'd be limited to no more than 2 entries within your 7-day period for the duration of the agreement, unless, of course, you can obtain mutual agreement from the tenant in those circumstances.
And some repair needs priority attention. So it could be maybe either emergency or a routine, but can an owner enter before the 48 hours notice?
Yeah, look, the Act provides exemptions, as you mentioned, from the 48 hours for emergencies and to protect the premises from imminent or further damage. And also, I mean, in those smoke alarm or electrical safety switch situations. If you've arranged for repairs to be done, you do need to provide the 48 hours, unless, of course, you can obtain mutual agreement from the tenant. And let's consider reasonably that if the tenant has requested repairs to be done, they're probably likely to, you know, allow that entry. And considering the difficulty at times in getting hold of tradespeople, communication's really the key here to ensure that the tenant's aware of what's happening.
Okay, and we know that this occurs. Does the sales agent still need to give a copy of the entry notice to the managing agent for each inspection?
Yeah, so the Act hasn't changed regarding the requirements here. So a secondary agent, which we usually the selling agent, has to provide the Form 10 before or when the first entry occurs to show a prospective buyer. And they're required to provide a copy to the renting agent. So unless the renting agent otherwise agrees, they are still required to provide a copy of each entry notice. And that goes to the point you made around both parties knowing what's happening and not entering more than, if it's in relation to that ending notice, that either party's not entering more than twice in that 7-day period.
Mm. And again, it comes down that 7-day period starts from the day that the notice is served. So after that, obviously, then each time there's an entry that's occurring, you're starting to count those entries. And then if you have actually maxed out no more than twice in that 7-day period, well, the only way to get through really is on mutual agreement.
Correct. Yep.
Okay, so one of the key changes coming from 1 May is a new standardised rental application form. So there will be two forms, one for general tenancies and movable dwelling, and also another form for rooming accommodations. So a Form 22 and a Form R22. So this would be used for when a prospective tenant is applying for a rental property. Now, property managers and owners will need to provide two ways to submit an application and ensure an option to submit the form is available other than using a restrictive way, such as like an online platform hosted by someone else that is not the manager or the owner. So, as an example in this case, so if a manager was using an online or digital application, they would need to ensure that they are offering another option. So that may be offering like a paper form or another option, making sure that it's accessible for everybody as a prospective tenant to apply for that property. So there are also guidelines on what information can or cannot be requested from a prospective tenant during the application process, and I'll step you through what the Act says shortly. So it's also noted here that the legislation uses some new terminology regarding a relevant lessor. So in a nutshell, there is a general exemption here for social, community and public housing organisations. So as part of this particular process. So this is for organisations that fall into the categories of coverage under the Housing Act 2003 or funding under the Community Services Act 2007, or is a state or replacement lessor under community housing provider tenancy agreement. So those exemptions are in place. So we know too that the Act and regulations are very clear about what the requirements are for the application form and the process. So any applications submitted before 1 May but is still being processed after 1 May would not be captured under the new laws. However, any applications submitted from 1 May and onwards will need to be captured. So the legislation outlines what information or the documentation that can be requested. So name and contact details, current employment, income details, referee information, the term of the tenancy, details of any previous tenancy or rooming agreement, and any other information prescribed by a regulation. So we know last month the regulations were released and what they include to be added to the application form. So what does that look like? So the regulations allowed for additional information to be captured. So this now includes a date of birth, number of tenant or residents to reside, and number of who are under 18 years old. Number and type of vehicles to be housed at the property, so whether that's like a car, a boat, heavy vehicles or a motorbike. Also to financial ability to pay rent. So this expands the option for income details, and also to the number and types of pets to be kept at the property. Now, there's also a limit of no more than 2 documents in each of the following categories. So, identity verification, financial ability to pay rent, and suitability of the prospective tenant or resident. So, a prospective tenant may choose to show or provide a copy of the documentation. And if a document is accessed or cited by a manager or an owner, they must not keep a copy of the original identity document without the prospective tenant's consent. So, there is penalty units that apply throughout this application process, and I'll talk a bit more about them. The other part is that a property manager or owner cannot request directly from the tenant the following, and that's evidence of legal actions taken by a prospective tenant or resident, including disputes or matters considered by a tribunal, information on previous remedy breach notices, the prospective tenant resident's history regarding rental bonds, including any claims, and any statement that detail a potential tenants or residents' credit or bank account transaction history. Now, the Act does not prevent a prospective tenant voluntarily providing extra information, but a prospective tenant or resident may wish, and it's up to them if they wish to volunteer that. But additionally to the process of asking a referee for this information has not changed. So the restriction does not apply to referees. It is only there in place in relation to asking this information from a prospective tenant or resident. So your referee, whether that might be a previous owner or a previous manager, you may be a property manager or an owner is in a position where they can actually ask as part of the referee checking whether or not there may have been a breach notice, as an example, being issued. Okay, so just to summarise that, the application form and what documentation can now be asked for or provided as part of that supporting document is covered by the legislation and regulations. The selection process or business process in doing referee checks still remains the same, or what you might find that's in current practice today. Now, the decision to approve or not approve is still up to the property owner or manager at the end of the day. So the application is putting a structure around what an owner or manager can request. And what you may find is that the standardised application, tenants may start completing it early and getting their information ready before inspecting the property, which may actually help streamline the time frame in being able to process applications quicker. Again, a tenant may volunteer more information, but an owner or manager cannot request or ask for more than what's the requirements of the Act. Okay, now one more thing here, as I mentioned before, is about the penalty units that are throughout sections 57B to D. About the process. So just outlining that not using the standardised application form, not offering 2 ways to submit an application, or requesting more personal information or more documents than the guidelines allow, they do have penalty units attached. So if a manager or an owner is using an online platform or third-party platform, they need to ensure it meets the legislation requirements and it is compliant. Now, I know, Mark, this is a popular topic. We know that. So I'm just going to come back in, and these are the questions that we are getting asked, and it's actually evident too, these are the questions that we're getting submitted in as well.
Mm-hmm.
So can I use my own version of the application form?
Yeah, look, it's the responsibility ultimately of the property manager or owner to ensure that their application form is compliant with the Act and the regulations. So we encourage property managers to use the application form available on our website. And as you mentioned, any non-compliance with the Act is There's penalty units attached to that, but we do encourage using the agreement that will be posted shortly on our website, and ensure that you're using the most up-to-date form. If your software provider provides a copy of that form, as long as it's substantially compliant with what we end up producing as the application form, then as similar to the use of other forms in those circumstances. But the substantial compliance is the key here.
Can a property manager ask a referee about previous breach notice or bond claims as part of that referee check? And I think that's just to make sure we have that clarified out there.
Yeah, look, the Act prohibits property managers or owners from obtaining that sort of information directly from the prospective tenant, but it doesn't extend those restrictions to third parties or other entities. So while property managers or owners are not prohibited from accessing that information from external sources, we do encourage them to focus on assessing the prospective tenant's ability to meet their financial obligation and look after the property.
Yeah. What if a tenant doesn't have a pay slip as proof of income?
Yeah, good question. And we've seen this come up a little bit. So documents that can be used to verify a tenant's ability to pay rent may include things like pay slips, bank statements or other financial documents. If a prospective tenant's not receiving a regular income, so if they're self-employed or casual, they might choose to include previous details of employment or other documents supporting their financial ability to pay, such as, pay slips from previous employment, bank statements. As said, obviously the transaction details need to be redacted unless the tenant chooses to provide them. Centrelink payments, proof of savings or assets. But what we really encourage here is the tenant to have a conversation with the property manager or owner in that situation to verify their ability to pay in that circumstance.
Now, if a tenant shows ID, can a property manager still write down the details?
Look, when proving identity, a prospective tenant can either provide a copy of the original identity document or allow the property manager to access or cite the original identity document. So and recording details, if they only allow you to cite, we would suggest not.
Okay, and oops. Can the RTA's dispute resolution service help if an application has been declined?
No. So as that slide that you popped up with the 4 steps shows, our application process or the application form is there for the tenant to fill out to provide that information. Once they've done that, the property manager or owner, it's up to them to make a decision as to whether that tenant is suitable or not. The tenant can't come back to us seeking dispute resolution if they've been rejected. So in those circumstances, no, they can't. The dispute process is really there for, once the tenancy has started, and issues that might arise throughout the term of the tenancy.
Right. Okay, so I know that there's a lot of questions in this space, and I know that people are looking for the application form. Mark, do you want to maybe just give us a bit of an update on that?
Yeah, so where we're at with the application form at this stage is that it's currently being refined. So we're just looking to ensure that it complies with the upcoming changes and is able to be used effectively across the sector. So we're working to have this completed as soon as possible, and we'll update our website once it's available. So we know people are keen to get their hands on it, but we are just tweaking it, and it will be back up fairly soon, hopefully.
Yeah, and I think too, once that's done, that probably answers a lot of people's questions. It'd be quite an easy to read sort of document as well. Okay, so the next change, and we'll probably come back to, I've just put a message thanking everyone for their questions. There's also a lot of duplication around the questions that we are getting asked. So we will come back to go through questions shortly. So the next change is around putting an official process around the request for fixtures and structural changes. So there's going to be a new form, Form 23. This is available for general tenancies, movable dwellings, and room accommodation. So one form that does all three. And that's for the resident or the tenant to complete when requesting any fixtures or any changes. Now, a property manager or owner will have 28 days to respond to the request. And also note here too that if there's no request, then it's not approved.
No
So,
response.
this is actually, it's unlike, in the PET approval process or the framework that was put in place back in 2022, there was a time frame that if it wasn't responded, it was it could be approved. But in this particular case, if the approval is not granted, it doesn't mean it's automatic at all. So the approval must be in writing, describe the fixture or the change, and specify any conditions. So conditions as part of the approval may include the maintenance responsibilities. It may be permission to remove the fixture or procedures for removing if that's been allowed, repairing any damage. It could be that there's compensation if the removal is not allowed for the improvement made. And also note here too, for anyone that is either renting in or managing units, apartments or townhouses, that there may be body corporate bylaws and therefore body corporate approval requirement is required for the tenant to do this. So it's a separate process, and the 28-day timeframe doesn't apply. So this is actually like a motion or request being put to the body corporate. They just need to respond in a reasonable, practical time frame. So again, the two processes could be running parallel. This is all more important therefore, like if someone's looking to change the appearance of a lot. So it could be like hanging a pot plant or putting up a clothesline. So again, that body corporate permission is required first. So if you have any questions on body corporate, please jump on the Body Corporate Commissioner's website for anything in that space. So the questions that we are getting in here, again, it's just putting a structure around what's already really in place and putting a time frame in there. So is there a standard response form for owners to complete to reply to the request, Mark?
Not specifically, Lynn. The Form 23 that we've created provides for the tenants to provide all their information in requesting. Page 3 on that form actually provides for the owners to respond to the tenant's request. The key here is that the owner needs to go back with 3 key pieces of information. So whether the request's been approved or not, a description of the fixture or structural change, and then any other conditions for approval that may state additional reasonable conditions rather for the approval, or if the approval is subject to agreement by the body corporate, which you just spoke about.
So does an owner have to give a reason to why a structural change is not permitted?
No, they don't. But the legislation does say that they must not act unreasonably in refusing the request. So, and then what the new legislation also provides for is obviously the tenant to continue that communication with the owner in regards to their request. And if so, or if they're still unable to resolve it or get approval, they can come to us for dispute resolution. And if we're unable to resolve it there, it can go to QCAT.
Yeah, so the new Form 23 is going to apply general tenancy and rooming, isn't it?
Correct, yep.
Can an owner request that the work be carried out by a professional contractor rather than the tenant doing the work themselves?
Yes, they can. They can put that in as one of the conditions of approving the request. Absolutely.
Can an owner or manager request longer than the 28 days to respond, which this might actually help some of the questions that we've been getting as well?
Yeah, so the Act actually provides for, it says 28 days, but if the parties agree, mutually agree for that period to be longer, and that may be in relation to, body corporate approval, or it may be in relation to, needing checks to see, how, when the work can be done or any of those particular things. So yes, there is that option there available to both parties.
Okay, so just to also clarify here that, again, if the owner doesn't respond in the 28 days, it's not an automatic approval. A tenant would actually have to go through dispute resolution, which then leads to, can QCAT make a decision if a dispute occurs? So if the owner doesn't agree with the request and the tenant goes down that path and the matter ends up going off to QCAT, can they make a decision?
Yeah, they can. So as I mentioned a moment ago, if the owner does initially refuse, then the tenant can come to us for dispute resolution, and if unresolved, it can go to QCAT. Now, excuse me, there is a list of things within the legislation that QCAT will need to consider or should consider. So it might be around how the change might improve safety, security, or accessibility for a tenant, if building approval is needed, or even to the extent of whether the change can be removed at the end, or the premises needs to be returned to the condition it was, or that the fixture or structural change stays there and there's some form of compensation provided from the owner. So,
Yeah.
um,
And
we'd
so part of
encourage,
that, oh, sorry, I was going to say part of that too is like it may be that the tenant says, I'll pay to do this, or I will, I'm looking to request this. Yeah, is it reasonable and things like that, isn't it?
yeah, exactly right. So, and that can be sorted out and can be a part of the agreement, that tenant pays for it. The owner might choose to compensate at the end. There's any number of um, ways that that can play out. So,
Yeah. And the QCAT application is a non-urgent
correct.
application, so coming through the RTA's dispute resolution process first.
Yep.
Okay, so just before we wrap up and look at everyone's questions, any financial benefit received by a property manager or owner regarding rent payments must be disclosed. So if a manager or an owner is using, like, as an example, a third party platform where there's a financial benefit that's being provided, it needs to be disclosed to the tenant. Now, this is very different to, telling the tenant what costs that they are up for if they're paying rent. So that was involved, that was put through last year, that a tenant must be made aware of any upfront of any costs involved in paying rent. So, but what will happen as a one made, that actually does have penalty units attached to it if that doesn't occur. Okay, so on your screen, and I know, Mark, I think you actually might have put in a couple of links along the way in the chat, but if you scan the QR code on the slide that you see on your screen, it will take you to more specific information on our website about the law changes. We have fact sheets, information, videos, podcasts available, so a variety of different resources to help you and everyone in the sector be informed and be educated in this particular space of the new changes. We also have a page that is frequently asked questions, so it actually adds more information about further than what we've just gone through today, about some of the common things that we've actually heard and what people want to know more about. Just quickly before we go to your questions, again, a lot of information on our website. Today, I know that we've also got a lot of questions that's been submitted about other topics. We won't be able to address that today. Our friendly contact centre staff is also there to assist you with your tenancy or bond queries on our 1300 number. And for anyone that's social media savvy, you can follow us on LinkedIn. And as of 2 weeks ago, the RTA also joined Instagram. So again, feel free to follow us on that. Okay, so let's go to some questions, Mark. And I've got to scroll all the way back up here. Just give me a moment
I think,
to.
Lynn, one of the questions, or there's a quite a
There's some
series of
themes, isn't there,
questions,
really? Yeah.
yeah, around the application form, and privacy consent, ticker listings, and those sorts of things. So, I guess the easiest way to answer a lot of those questions in that situation is wait for the updated application form to come out onto our website. So it is being refined in relation to some of the feedback that we have received. So I think, yeah, as opposed to go through any of those individually at this stage, there's been some changes and updates made around some of those particular things. So that, yeah, and
That might actually
it's
resolve that.
Rolf, yeah,
Yeah. So if I go back through to one of them, which is about the destroying of information at that 7-year mark and things like that. So does it apply to existing tenants in your system that may already be more than 7 years of age, 7 years old? So it's 7 years after the end of the tenancy. So that's the key point that triggers the 7 years. So Mark, yes, it potentially would be that some people might actually have to
Yeah,
start going through their digital
records,
records and things.
correct.
Yeah.
Yeah, it is retrospective. So effectively, come the 1st of May, anything that you've got in your system that's older than the 1st of May 2018, you'll need to start to securely destroy that information.
And also to one here about like entry for open homes and things like that. Well, an open home is still an entry. And again, for open homes, you still need to get tenants' permission to conduct that open home, don't you?
Yeah, you do. And I guess along with that, there's a few questions in there, Lynn, around the mutual agreement and does the mutual agreement it count as one of the two within the 7 days? In effect, it does.
Mm,
You can seek, if you've issued an entry notice to enter for a particular reason, and then you have another reason that you need to enter and you seek mutual agreement from the tenant, if there's another entry notice in place within that 7 days, the tenant might choose to say, well, no, you've already had your two. Yes, I've
mm.
agreed, but you've had your two. So it really is around that communication with your tenant. But one of the things we see at times, if there's a group of prospective tenants, for example, that want to go through, the tenant might be happier to have a number of entries in a short period of time and then be left alone for a period. It's really that communication and working through that process.
Yeah. And as you said, there's a lot of queries about the application form. So we just might just, if everyone can just maybe wait a moment until that actually does come through. But I did make a mention about like the third party, the online platforms and things like that. Those organisations, not mentioning, I know that people have mentioned them, will need to be compliant for Queensland for what our legislation states.
Yep, correct.
Um, can we still ask about smoking?
Yeah, there's nothing preventing you from putting into your tenancy agreement that smoking is not permitted indoors. It's not considered to be discriminatory, and that hasn't changed for in regards to this upcoming legislation change. So no issue there.
Okay, if a tenant cannot provide proof of income and they're providing a bank statement, yeah, about the proof of income and things like that. With the bank statement, so they do actually have to have those individual transactions de-identified. Is that right?
So the if you request a bank statement, then the tenant has the ability to de-identify. I think the legislation says that can't include more than the name, address, and the balance. If the tenant chooses to provide information or leave particular transactions open and viewable, then that's up to the tenant to provide that to you.
There's a couple of comments about getting involved in relation to legislation and things like that. Always, that's always been available for anyone in the sector to make feedback or comments to the Department of Housing when they were doing, obviously not just consultation, but any feedback was always available through to Department of Housing. Keep in mind, the RTA, we don't write the laws, but our job is to implement the legislation, and that's part of our role. But anyone in the sector, or if anyone's not is concerned about the changes that have happened in the last 12 months, again, that's writing to your local member of parliament and expressing your views and concerns through that particular channel. And again, that comes down to, like, there's been some people asking about repealing the changes and things like that. And again, that's talking to your local member, or talking to sending your request through to Department of Housing. I think that's probably, as I said, a lot of them has actually been duplicated up here. But if a can a owner request that the tenant pays for a change, if they're requesting the change or the fixture, can they owner request that the tenant pays for it?
Yes, they can. And one other question that I saw in there in relation to that was around compensation. Do you have to compensate? No, you don't. That the idea of this is to work out what that change is going to be and what the conditions are around that change. You might, as opposed to requesting the tenant to compensate, actually ask them to return the property to as it was at the start of the tenancy. So they would need to remove the fixture and bring the condition of the property back to the way that it was at the start. So all of those things are on the table, and it's really around that communication with your tenant in that circumstance.
Yeah. There's a question too, and we'll just do this before we wrap up too. Does a property manager have to disclose any benefit that they receive from a tradesperson when they allocate work to a tradesperson? Now, that's not really in the Act. The Act talked about any benefit for the rent side of it,
Correct?
but there may be some other rules in relation to office fair trading between like the agent and a landlord there, and if there's any benefits that might actually need to be
Yep.
disclosed, that might be a separate situation rather than what we actually have in our legislation changes.
Yep. Can I just address, Lynn, before we do finish up, and I appreciate the time and thank everyone for sticking around. There's a couple of questions in here around social housing and community housing providers and those sorts of things. Important to remember that if you're a community housing provider and you are exempt from the 12-month rent 12-month rent changes, that makes you exempt from the requirement to the new application form. So there's a question around if an applicant's been on a waiting list before or after the 1st of May. So it won't make any difference if you receive funding under those two acts that Lynn mentioned earlier, then you're not required to use the new application form.
Excellent. Thanks for clarifying that, Mark. That's it. We've gone through a little bit today, and we do appreciate your patience in hanging around with us a little bit longer than we've gone a little bit over time, so we do apologise for that. Please, as I said, jump online to our website. There is a lot more information there. And again, once the application form is released, that will probably answer a lot of questions in this space for you, particularly around, the information that's required and also the ticker and things like that. So please do watch this space. Thank you again, Mark, for joining me today and helping me with all the questions. As so, it's been a very busy morning. And again, thanks everyone for joining us. And please jump on board our website. And also, too, we look forward to seeing you maybe at one of our upcoming events across Queensland or at our next webinar.